Yeah, so my name is Dan Newhouse, and I'm a national civil rights advocate litigator. We've got a case against the state of Washington. We've been litigating for 9 years. We've given Mr. Newhouse plenty of opportunity to be able to, to discuss this with us and try to resolve this without any further litigation. But as of next week, we're going to be here delivering 500,000 criminal affidavits on behalf of affected litigants that's going to get this finished. When a state chooses to enact its own alternative legislation and substitute it with the guarantees of the Constitution, that is unconstitutional. Article 1, Section 26 of the Washington State's Constitution is facially unconstitutional, and it must be addressed. So we want to give Mr. Newhouse one last opportunity here before we bring this into the public domain and have this debate publicly without being an opportunity to be able to address this privately. So I have some paperwork here. We're happy to deliver it to you guys. I know that Mr. Newhouse is unavailable, but his staff is. If the staff would like to have a conversation with him.
Hey, Matt.
My name's Dan Newhouse. So when a state chooses to enact its own alternative legislation and substitute for guarantees Constitution, that is unconstitutional. So Clause 1 Amendment 5. Last I'll present my grand jury, Article 1, Section 26 of the Washington State's Constitution says no grand jury can honor someone in county.
Okay.
That's facially unconstitutional. So we've now got 500,000 criminal affidavits on behalf of affected litigants. Many of them are in the state of Washington. And we want to give Mr. Newhouse one last chance to be able to take care of this privately, or at least have a discussion before we bring this public. So as of next week, these affidavits are going to be delivered, and we're going to be finishing this case. And so we delivered action item requests. The last time I did it was about a year and a half ago. The chief of staff called me up and said that it's not.
Was it Amanda?
No, it was a gentleman. Yeah.
It would have been a lady.
Yeah, this was a man. He identified himself as chief of staff, but could have been.
We would not have had a male chief of staff.
Okay. Yeah. So, but nonetheless, we have an opportunity here. We're here for a couple of days, and we'll be back on June 6th to deliver this on June 9th to the court.
Chris is happy to take the meeting. You'll be on just a second.
Thank you so much. Thank you guys so much. Thank you so much. Yeah.
This is Chris MacArthur.
Yeah. Chris, I mean, right here, Chris? Yeah. Okay. We have 500,000 criminal affidavits on behalf of affected litigants throughout this country. That includes a number of them within the state of Washington. And so here's the position that we're in the So essentially what happened is, when a state chooses to enact its own alternative legislation, substitute for the guarantees of the Constitution, that is unconstitutional. And so when the Constitution of the United States requires an indictment by the grand jury, in Courts Clause 1 Amendment 5, that is a requirement that the states are restricted from. It restrains the states. So my focus is on Washington because obviously litigation is against Washington, right? We've enjoined these other states, all the states that do not conduct it or that permit their prosecuting attorneys to charge for information or indictment by their discretion, which is also unconstitutional. That's a direct violation of the 14th Amendment Equal Protection Clause, because you can't use your discretion abusively, break the law, nor can a state create a law that directs someone to break the law. That would be a moral violation. So, one of the reasons why we're here with legislators, because I know that you guys are going to say, well, this is a state issue, we abstain, but unfortunately that's not true because the 14th Amendment, the very last provision of the 14th Amendment says Congress shall have the power to enforce this article, which means that in the case of a violation of the 14th Amendment, be it Equal Protection Clause or deprivation of a fundamental immunity or privilege, then that would mean that the enforcement has switched from executive branch into the legislative branch, and now the legislators are constitutionally obligated to address this issue. So the last time I submitted an action item request to Mr. Newhouse, someone called me up from his office and said that this is not their responsibility to address this issue. When a state enacts a provision and amends the Constitution in an other than lawful manner, that's not the legislature's responsibility, and that's not true. The legislature is the only one that has the authority to be able to amend the Constitution of the United States. That's in accordance with Special Amendment Procedure of Article 5. They submit the amendment once 2/3 of both House and Senate pass it. Then, of course, it goes out to states for ratification. That's the only way that you can change it. It can't be done through a state creating its own law and imposing its will upon the rest of the nation. That's quoting Thomas Jefferson, a direct violation of Federalists. So the state of Washington does in fact have an unconstitutional provision in its inferior constitution as of this moment, Article 1, Section 26, when it directs the prosecuting attorneys to not charge by indictment when they're required to by Clause 1 of Amendment 5. And that means that there's a massive number of people that are unconstitutionally imprisoned on direct facial constitutional violations. That means that under Civil Rule 60B, those convictions are void, wholly without force or effect. There's nothing that Washington State has in place that's keeping those people there other than threat of fear on a void, unconstitutional judgment.
What was the clause in Washington's Constitution?
Article 1, Section 26. It says no grand jury shall adjourn or summoned in any county. Now, I know that this is someone else's response. This is someone else's issue. But I also want to bring it to your attention that it is an emoluments violation when you pay someone to break the law. And as of this moment, because the federal government is paying the state of Washington to house prisoners, and those prisoners are there unconstitutionally, then that means that the legislature is in fact paying for unlawful acts to occur. That would be the emoluments violation. And so there's a number of things, a number of reasons why Mr. Newhouse would want to get involved in this. But as I said before, we have over 500,000 criminal affidavits that are ready to be submitted to the Supreme Court to get this addressed and finalized. They've been building this for 9 years. So this is how it works. When the state chooses to enact its own legislation, contrary to the Constitution, and then direct its agents to go out and enforce it, that violates two portions of the Constitution. One is Article 1, Section 9, where it says no state shall create any law that shall impair the obligation of contracts, because all the prosecutors, all law enforcement are under a contract. They made a promise by the oath or affirmation they took that they will fulfill the future outcome. That's a promise of a contract. And therefore, as a result, when the state creates a law that directs them to not obey the law, that would be impairing the obligation of contracts. And the other one is the 14th Amendment, where it says no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. The privileges and immunities of United States citizens are without a doubt, infallibly, the First Amendment bill of rights, especially if it's enumerated. In Clause 1 of Amendment 5 is obviously enumerated. It says you cannot hold someone to answer for a capital or religious crime without an indictment by a grand jury. So when the state created its inferior provision that says we can charge by information, not by indictment, well, then that prosecuting attorney just committed a crime, because you cannot rely upon an inferior state statute to abridge an obligation that you have codified in the Constitution of the United States of America. That crime is called deprivation of rights of the color of law, Title 18, subsection 242. So when the prosecuting attorney commits that crime and then brings that incorrect charging instrument to a judge and says to the judge, I'd like you to hold this person over, that judge has to do the responsibility to make sure that the power that they exercise is consistent with their authority. If they choose to exercise their power because the prosecutor abused their power to bring the incorrect charging instrument, then that judge is also now exercising power under no lawful authority, also committing the base crime of deprivation of rights of the color of law. But now he's established a conspiracy by between himself and the prosecuting attorney. That's Title 18, subsection 241. Then when the judge signs that order, hands it off to a law enforcement officer and asks him to go out and make an arrest, the officer also has a duty responsibility to make sure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the judge's abuse of power, who relied upon the prosecutor's abuse of power, who relied upon the inferior state statute to deprive a person of right guaranteed by the Constitution, now that officer is also depriving rights of the color of law. He's a member of the conspiracy, and the moment that they make an arrest without lawful authority to do so, the crime of kidnapping has occurred, and it is a federal kidnapping offense 1201 because they're holding the victim over for ransom in the form of bail, and anytime you have ransom, it is always a federal kidnapping offense. This is a serious matter, because anytime that you have kidnapping that occurs in conjunction with deprivation of rights in the code of law, the punishment that's prescribed by law is death. It's a very serious offense. I don't want that to happen. I want this to be very, very clean, because the people of the United States deserve to have this be much cleaner than it needs to be. But this can be very messy. I don't want to start arresting judges, but we have 500,000 federal crimes that are being committed by judges and prosecutors across this country that I've now collected over the last 10 months here. In almost every single
Washington, what other states are located?
So Connecticut in 1984 enacted a provision in its constitution that removed the grand jury. Connecticut, so in 1984. Also, around the same time, Pennsylvania removed theirs. It's also North Dakota, South Dakota. It's also Michigan, Florida as well. And so the majority of the states the majority of states permit their prosecuting attorney to charge by information or indictment, like such as Oklahoma. What Oklahoma's Article 2, Section 18 says, it says that the prosecuting attorney can charge by information or indictment by their discretion. And unfortunately, that is also unconstitutional because you cannot create a law that allows them to abuse their discretionary authority with which they're vested in law to break the Constitution of the United States. That would be the emoluments violation that exists. And so every time the prosecuting attorney chooses to charge by information, not by indictment, that action, that arrest is unconstitutional. It relies on direct facial constitutional violation, which means that everything after it is unconstitutional because it's all tainted by the legality of the language it's obtained. Mr. Newhouse, I think that he needs to at least think about this, right? Because this is a big deal. There's more than 700,000 people currently in prison here in America on direct facial constitutional violations because the states involve very basic procedures and processes codified by the Constitution in the adjudication of crime.
I guess my hesitation is just, I mean, there's not a lot of laws and constitutional clauses out there, which admittedly, I mean, I understand the Constitution a little bit, but I'm not as well versed as you are in this.
Mm-hmm.
So, if this has been an issue since 1984, why are we just, why is this coming up?
The Supreme Court of the United States is refusing to acknowledge it. The reason why this happened was that in 1833, the Supreme Court of the United States came out and said that you don't have to have an indictment by a grand jury. That was a ruling that the Supreme Court of the United States said. But unfortunately, and this is what we're litigating, is does the Supreme Court of the United States have the authority to amend the Constitution of the United States? And they do not, because all legislative power is vested in Congress of the United States, consisting of the Senate and House of Representatives. That's Clause 1, Article 1. All legislative power is vested right here in the legislative branch. No other branch of government can deal with legislation. That's make, amend, and destroy law. So when the judicial branch creates a ruling and erroneously calls it law, case law, and then directs all the states that they don't have to follow the Constitution of the United States, what happened there is that the Supreme Court of the United States amended the Constitution in an other than lawful manner through judicial fiat, and then directed all the states that they don't do it. That's where we're at today. That's why we're in the situation that we're in. Now, you guys, last year we had the Chevron ruling, right? Chevron. And Chevron was all about the executive branch not following the law either, because they were looking at it saying, oh, it's not clear, it's ambiguous, we're now going to write policy and then direct our agents to enforce that policy. Chevron was all about the Supreme Court of the United States coming out and saying, executive branch, you don't get to legislate. That's what that was about. And that was because I went around and I served 46 state attorney generals with the notices saying that the attorney generals, your prosecutors are acting unconstitutionally because they're following inferior laws that were created by the state due to policy, right? And so that was the reason, that was one of the main drivers behind Chevron happening. But if we want a Constitution Foundation, guys, there's two things that had to happen. One, the executive branch doesn't create law. They create orders. Orders is not law, right? And that's what Chevron was all about in 2018 last year. That was because I went to serve the 46 state attorney generals, right? Now, the next thing that we need is we need the judicial branch to own up to the fact that they don't make law either. When you create a ruling and it is contrary to the law or it amends the fundamental rights of the people, that is unconstitutional. Supreme Court, if you don't like the way that we're doing things or the way that we require you to do it, you're obligated to do it, that's fine. Present your case to the people of the United States and change the Constitution in a lawful manner. But if you don't, then what you've done is unconstitutional, and the truth is that it's sedition, because sedition is defined as speaking or writing of words such as law established in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner. You cannot change the Constitution in an other than lawful manner without committing a crime of sedition, which is treason. Again, I'm not saying that that's what needs to happen, but the Supreme Court of the United States has been obstinate on this issue, and the legislature needs to step up and say, no, we amend the Constitution of the United States, not you, Supreme Court, and what you did in 1833 was unconstitutional, and that's gotten us into the situation that we're in today, where someone's going to have to address this issue. Because typically the response that I get from the Attorney Generals and the Supreme Courts, because I served all the state Supreme Courts as well. So this last year, I've served every single Attorney General, right, the highest law enforcement officer within the state, controlling all the prosecutors, as well as also the state Supreme Courts, right? So they control the judges. So I've informed the highest agent in all 46 states that these crimes are happening, and they failed to take action. Now we need the legislature to step up and decide, are we going to preserve the Constitution of the United States? Because if we're not, then that court no longer has the authority to exist. Because the only thing that allows for that court to exist is Article 3, right? And if that court can't step up and defend Article 3, defend the Constitution of the United States, then in doing so, they will have ceded their power back to the states, and the state judges are more powerful. Because if the state judges are able to act contrary to laws that they're obligated to adhere to, then that means that we got a big problem, and that's not the Supreme Court of anything. Because they will have ceded their power back for their failure to preserve the Constitution of the United States. And the same challenge I would make to Mr. Newhouse here. If Mr. Newhouse recognizes the fact that he is responsible for amending the Constitution of the United States, no other entity of government can amend it or initiate the amendment of a Constitution. Therefore, when a state does amend it, he should be deeply offended that that happened, because that's his duty, that's his separate powers, that's his responsibility. States do not have the authority to go against the Constitution of the United States, because the only thing that makes America America is that Constitution. Nothing else does it. Okay.
Have you had the opportunity to present this for the Judiciary Committee staff as well?
No. So I've been here numerous times, and we haven't gotten any action. Usually, what happens is I come in, I meet with you guys, not you guys, but I meet with someone, and then I come back the next day, and as soon as I come back, nobody's around. They want to take a card at the door, and they say we don't want anything to do with what you have going on.
Well, I would say, yes, it's obviously the budget member of Congress. However, we don't serve on committees of jurisdiction that would make this the most.
Yeah. The reason why I'm here is because, one, Mr. Newhouse was my representative, right? So, being from Washington State, before I moved here, this was my representative. I did an action item request, and also Washington is the primary respondent in this litigation that we got against at the United States Supreme Court. And we've enjoyed all the other states, right? Because of the service that I provide and their failure to take actions like they required. But the argument is going to be against the state of Washington. And, so that's why we want to give Mr. Newhouse an opportunity here.
Opportunity for what?
Opportunity to be able to consider this issue. Because his own state is depriving his constituents of fundamental constitutional rights every single day. Every single day. And it's been going on for as long as the state of Washington has had a constitution. That's a problem, right? And as I said, I've been litigating this for 9 years. I've taken this through the state courts. I've taken it through the federal district, federal circuit, and we're now at the Supreme Court. And the Supreme Court has obstructed this and ignored it. But that's why I went out and I got 500,000 criminal affidavits. We have 200 boxes of affidavits from actual victims that have been charged by way of information, not by indictment, all across this country, including the state of Washington. So Mr. Newhouse's constituents are being deprived of their basic fundamental constitutional rights under state authority, and that's something that should deeply offend him.
I will say, I'm not an attorney, so I'm not.
That's fine. I'll debate the attorney issue in the court.
But happy to look into this a little bit further. I'm going to say that your best option is still going to be the Judiciary Committee staff. I mean, they're going to be the ones who have the investigative authority to look into this matter further.
That'd be great. If Mr. Newhouse believes in this and likes it, then perhaps he can help with that introduction. But I'm not getting anywhere with the legislature because legislature says this is a state issue.
And also typically when there's litigation already involved, we tend to stay on it, frankly.
So the case is not filed, right? I'm trying to do this in the least destructive manner. Right? I delivered the writ to the Supreme Court. They've had it. Mr. Gorsuch is actually, his book Overruled talks about everything I'm talking about. Judges don't create law, right? So they're very, very well aware of it. But it's not filed because I don't want to go down the messy path. I would much rather have people stand up with me and say, let's fix this, than have to go through litigation to force people, because that's going to bring us into public domain and it's not going to look good for anybody. That was what I said to the representative of Rhode Island when I met with him up in Rhode Island a few months ago. I mean, I don't want to do this in a messy way. I want us all to work together. But if we can't work together to fix the problems and preserve the Constitution, then we do have to do it the messy way, and that's litigation. And that means that there's 500,000 capital crimes sitting in my car right now of judges and prosecutors all across the country, and I don't want to have to do that route.
So what's your immediate plan? What's your next step?
So we're in the middle of a tour around the country. So we've been doing 40 press conferences over the course of 40 days. We're leaving here today to go finish the Northeast. So we're going to go to Philadelphia tonight and then up into Connecticut. I think we've got 8 or 9 stops left. We're ending in New York on June 6th. And just so you guys know, I served the state of New York on behalf of Mr. Trump before he was convicted, before he was elected on June 6th of last year. The reason being is because Mr. Trump was denied the right to be present in the grand jury to confront the hearsay accusations that's against him. That's a crime. It's called obstruction of justice. And by that crime, his arrest was unconstitutional. Therefore, everything after it is unconstitutional. The purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. The purpose of the grand jury was to protect Mr. Trump from a prosecutor that was trying to prosecute him without justification or authority, right? Because there was no crime was committed. So when the prosecutor conspired by and between the accuser, Stormy Daniels, to deny Mr. Trump the right to be present, to benefit from the very proceeding that exists for his protection from the prosecutor, and when denying him, then he was charged by information, not by indictment, because you must have the accused be present in the proceeding that exists to protect them from. So I served on the state of New York on his behalf. I served the Attorney General as well as also the state Supreme Court on his behalf. It wasn't for political reasons, but it was because I knew that he himself was affected in the exact same way that we're talking about these 700,000 people right here. Mr. Trump was unconstitutionally and illegally prosecuted. Therefore, the moment he was arrested by information, everything after that is void. There was no trial because the trial derives from an unconstitutional arrest when the state committed a crime in order to secure that indictment. So the next step is we're finishing up June 6th. We're finishing in New York. We've got a rally at the Freedom Tower there in New York. That'll be the last rally that we'll do and last press conference. And then we're coming back down to here. We're going to be here on June 7th and June 8th doing whatever rally we can out on Ashland Mall. We've got some organizations that are involved, and then we will be delivering the rest of this paperwork and all these affidavits to the court. But we would be more than happy to give this to the FBI if Mr. Trump will direct his Department of Justice to address this. Because the crime of deprivation of rights of the color of law, the only agency that can investigate that is the FBI. But if the FBI is going to continue to be absent on this, then then we're going to have to bypass that, and I'm going to have to do this on my own as Private Attorney General, empowered to be able to do so under the laws of RICO. But I would much rather do this together than apart. Okay.
All right. Well, well, happy to still look into this more. I don't have a strong answer for you one way or another right now, so I'm happy to hear it out. And
thank you guys so much.
Yeah.
Here's contact information. You guys and we will. If anybody wants to talk, we'd be more than happy to come back. But right now, we've got to move forward. Okay. And move forward under the assumption that we're not going to get the conversation with people that we need. Okay? All right. Thank you guys so much.
Thank you.
Thank you. Thank you. Appreciate it. Have a great rest of your day, guys.
Thank you.
How's this look?
Yep. Just one phone.
Thank you guys so much. God bless.